I'm so delighted to welcome everyone to our annual John Gedid lecture, sponsored by our Law and Government Institute. I'm delighted for a few reasons. First, John Gedid is a mountain of a man at this law school. He was with us at the beginning. He deaned us through our first accreditation period and series, and he founded our Law and Government Institute. And John has been so gracious and generous in his retirement years to the law school that I love this lecture because it honors John's memory. And he's still with us, so I didn't mean memory. It honors his life. Second thing is the Law and Government Institute. It's one of the foundational pillars of our law school. I absolutely love. I just had a second to share with Jennifer that because of our Law and Government Institute, Nicole can correct me if I'm wrong here, but about 60% of government jobs are held by Widener Law Commonwealth graduates. We dominate the state government and the work that we do in the state. And we are the Attorney General, and we're the right and left hand of the governor. And our Law and Government Institute creates jobs and opportunities for our students to do critically important work in state government, which Jennifer will be talking about with us soon. So, the Law and Government Institute is one of our signature programs. It focuses on the complex intersection of legislation, regulation, public policy, and the law. We have three main objectives in our Law and Government Institute. They are first, to help our students earn specialized certificates at graduation in a myriad of ways: administrative and constitutional law, environmental law, government contracting, and/or legislation and public policy. Second, we contribute to the development and growth of government law through scholarly and employment opportunities. And third, we host programs like this that explore and debate important topics of government law. And we're really delighted to have Jennifer Ngo with us here today. One of the programs, as I suggested at the outset, is our Gedid Lecture. It honors John and everything that he did for our campus. He was here with us from 1989 to 1995, and he was the founding vice dean and then served as vice dean again from 2007 to 2009. A few housekeeping issues before we begin. First, we are recording this program, so your continued participation sitting here means that you're assenting to being recorded. The program is eligible for CLE credit. If you're an attorney seeking CLE credit, make sure that you get the form that's available at the front check-in desk. And the link will be dropped into our Zoom chat as well. Also, welcome to all of our Zoom visitors that are here with us this evening. Finally, there will be time for questions at the end of Jennifer Ngo's presentation, and we will be monitoring the chat for questions. If you have a question in the audience, raise your hand. If you are on Zoom, we will monitor Zoom for any questions. Okay, so now I'm really delighted to bring up Alex Benson, who will introduce Jennifer Ngo as our Gedid lecturer. She is a third-year student who will be graduating this May with a certificate from the Law and Government Institute, and Alex serves as the president of the Law and Government Student Society. And having gotten to know Alex a bit over the last couple of years, Alex is fabulous, and we're fortunate to have her. Alex is one of the members of our law school community. So let's have a fantastic Gedid lecture. Alex.
Thank you, Dean Cummings. It is my honor to introduce Professor Jennifer Ngo, the Ruth Wyatt Rosenson Professor of Law at the University of Chicago Law School. Professor Ngo specializes in administrative law, separation of powers, executive branch dynamics, and regulatory policy. Professor Ngo received both her undergraduate and law degrees from Yale, and she also received her Master's of Philosophy in Politics from Oxford University, where she was also a Marshall Scholar. After law school, she clerked for Judge Richard A. Posner of the U.S. Court of Appeals for the Seventh Circuit, and then Justice Stephen Breyer of the U.S. Supreme Court. She has served twice in the federal government's Office of Information and Regulatory Affairs within the Office of Management and Budget. Professor Ngo's lecture today is titled "The Para-Presidency, the Department of Government Efficiency, and beyond. Please welcome Professor Jennifer No.
Thanks so much, Alex. Good afternoon, everyone. It is a pleasure and an honor to be here with you all as part of this lecture series to honor John Gedid. What foresight and vision he had to establish the Law and Government Institute. I can think of few more important times in history than now to educate law school students and the public about the critical role of lawyers in government today. As Alex mentioned, I myself have been fortunate to work in government and consider that experience amongst the highlights of my career, and I continue to draw upon it all the time in my teaching and in my writing, including some of the thoughts I'll be sharing with you today. Finally, thanks also to Jill and to Rob Teplitz, Jill family and Rob Teplitz, for organizing this event and for their work directing the Institute and its admirable and important, critical, really, mission. So there can be little doubt today that we are in the midst of the imperial presidency. This development, of course, hardly began with the current administration. Rather, it has been the result of an accretion of power to the president spanning decades. And on this theme, my topic today will be what I will call the Para-Presidency, and its relatively recent role, I argue, in expanding presidential power in novel ways. Simply stated, the Para-Presidency is a domain of ex ante temporary governance. By that I mean it's ex ante, that's before the officials start, they know the positions are going to be temporary. It's an ex ante temporary governance, a domain of ex ante temporary governance that operates alongside, beyond, and sometimes in tension with the institutional presidency. As a result, it can be used to evade legislative constraints and judicial review, as well as to deflect blame for unpopular tasks. Moreover, unlike more familiar White House advisors, the Para-Presidency is largely exempt from various ethics statutes governing conflicts of interest and disclosure. So in our brief time together, I hope to develop this concept further, offer some types and examples of the Para-Presidency, discuss some of the implications, and then offer some nascent ideas for reform. And I'm really eager to hear potential ideas that all of you may have as well. Now, many of you have likely heard of and encountered the para phenomena more broadly. Okay, close to home, consider paralegals. Some of you might have even been paralegals in past lives. This category was first created by lawyers through the American Bar Association when they formed a committee to explore the best ways to train non-lawyers to meet what they perceived was the unmet demand for legal services. Paralegals often draft legal documents and pleadings, they conduct interviews and other administrative tasks. But controversy and bar disciplinary proceedings often arise when lawyers ask paralegals to give their clients legal advice or otherwise do what lawyers often do, despite paralegals, of course, lacking their legal status and passing the bar. Consider also paramilitary groups. Sudan's Rapid Support Forces. Here, the Basij militia in Iran, which is an all-volunteer armed youth organization, which for all practical purposes, according to observers, serves as the ground forces of the Islamic Republic. The Basij are often used by Iran's government to suppress dissidents, protests, and survey the population. They sometimes dress in plain clothes to infiltrate protests and counter-protest in support of the state. When challenged, they often resort to force to beat demonstrators. And in this manner, paramilitary groups are sometimes state-sponsored armed groups that adopt military-like structures and functions, but technically exist outside the formal military, thus the paramilitary nomenclature. Instead, they conveniently occupy this hybrid position between the military and civilians, and they're thus frequently used by the state for delegated and thus deniable coercive activities. What unites these para-actors as a conceptual category is, again, that they operate alongside and in functional proximity to other formal actors, like lawyers, like the military, without sharing their legal status. Nevertheless, the root institution, again, lawyers, the state, the military, can use them to accomplish ends that they would otherwise not be able to do. And it is this fluid relationship that often grants these para-entities an unstable status that can evade meaningful political and legal accountability. My claim here is that it is useful to recognize that a similar group of actors has arisen in the context of the presidency, and to draw upon this broader literature about the paramilitary, the paraphenomena more broadly, to understand this development descriptively and normatively. So as defined here, the para-presidency, as I'm defining it, has three characteristics. One, they're created by the president, usually, though not always, by executive order. As I've mentioned earlier, they are ex ante temporary. I'll say more about that, but again, they're subject to time limitations or appropriations limitations in statute. And they are plausibly quasi-private. That is, they're not fully of the government, as they often retain their private occupations or affiliations, whether in industry, interest groups, academia, or elsewhere. Importantly, for my purposes, this image was generated by AI, disclosure, the para-presidency is distinct from traditional, these people will never be in the same room, so you can tell. These are distinct from traditional White House advisors who have long surrounded the president. Okay, so take a look. I've got Nancy Ann DeParle, White House advisor in charge of healthcare policy under Obama, right? A lot of familiar faces. John Podesta, right? Served in the Obama administration in the White House, also was in charge of clean energy initiatives in the Biden administration. I've got Jeff Zients. He looks slightly different, but this is AI. Anyway, Jeff Zients, who was the coronavirus response coordinator, right? And all these White House advisors, I will argue, are part of an increasing constitutional settlement. While they too are temporary in the sense that they're political appointees, their service is not constrained by time or appropriations limitations ex ante by statute in the same way that I'm going to argue the para-presidency is. So part of my claim rests on trying to convince you that there is a thing called the para-presidency that is distinct from these traditional White House advisors. In addition, these White House advisors are subject to ethics rules that often require divestiture and resignation. They are full-time and fully of the government. While their legality has been questioned, right, probably most prominently in the Obama administration, where there was a whole debate about White House czars, again, I want to argue that their status is increasingly settled. Okay, what do I mean by that? Well, first of all, Congress seems to have largely blessed their presence. In 1939, for example, Congress passed a Reorganization Act explicitly authorizing the president to have 6 presidential assistants. More recently, in 1978, it passed the White House Personnel Authorization Employment Act, which then expanded the president's authority, now to appoint 100 White House personnel at the highest levels of the government pay scale, and then many as appropriate at the lower steps. In return, Congress also required some limited disclosure of White House staff. So we now have a much better sense of exactly how many are actually being hired through these authorities and appropriations. And courts, too, increasingly are recognizing the White House advisors as a settled feature of the executive branch across a number of doctrines, right? Whether it's executive privilege or interpretations of the Freedom of Information Act, right? Courts seem to accept them as part of our constitutional order. In short, White House advisors are a domesticated feature of our legal system. I claim and submit. By contrast, once again, the emerging para-presidency is not. From what is known, the phenomena appears to be relatively recent. Unfortunately, getting hard data to substantiate this claim is really difficult because, if not impossible, due to the simple lack of disclosure. What is undoubtable, however, is that presidents have been using the para-presidency to accomplish their highest priorities. Okay, let's consider some examples. As my subtitle suggests, let's begin with DOGE. This image also generated by AI, or the so-called Department of Government Efficiency. They did not, in fact, parachute into the USAID, but the image is meant to parallel previous metaphors and analogies that I've already offered, such as the paramilitary. But DOGE, of course, was established by President Trump via executive order on the first day of his second term. The EO also created a so-called U.S. Digital Service Administrator who would report to the White House Chief of Staff. Interestingly, the EO invoked a statute authorizing temporary organizations within the federal government. 5 U.S.C. 3161 for those of you that are really interested. Got to get that CLE credit, right? So, pursuant to this authority, the administration created the U.S. Service Temporary Organization dedicated to advancing the president's 18-month DOGE agenda. Over the next year or so, DOGE hired, as many of you read in press reports, right, a cadre of software engineers, lawyers, and others, most of whom did not have any government experience, and deployed them to more than a dozen agencies to be involved in the cancellation of major federal contracts, to fire government workers. Remember the fork in the road email that was sent out? That was very much a DOGE initiative, and also to gain access to sensitive government databases. Though government lawyers denied it, widespread public reports and Elon Musk himself and his social feed suggested that despite there being this DOGE administrator, the U.S. Digital Service Administrator, that it was in fact Elon Musk calling the shots. Notably, Musk was hired as a special government employee while still maintaining his roles at SpaceX and X, formerly known as Twitter. This status, special government employee, what I will call SGE status, constitutes our first type of actor in the para-presidency. This SGE category was created by Congress in 1962 as a time-limited designation really to enable the federal government to take advantage of outside expertise, to try to get folks who were experts in industry and academia to serve in advisory capacities in the government, normally on low-level advisory committees or agencies, as opposed to high-level White House operatives. Okay, so there is first a real question of whether this SGE status can even be used to employ folks like Elon Musk into the White House. Based on the sparse public information available, however, it appears that the Trump administration's use of this same statute to appoint high-level advisors is unprecedented. And I have to be careful again because of the lack of data, okay? But given what we do know, including Musk, this administration appears to have at least 13 White House staff with this designation, all of whom work with very limited or sometimes no government pay. Okay, so they are on the payroll of their outside institutions. By contrast, the Biden administration had at least 3 reported examples, the most high profile of which was senior White House advisor Anita Dunn. Some Trump administration examples include, in addition to Elon Musk, Katie Miller, who was a high-level DOGE operative. As many of you know, she's also the wife to Deputy Chief of Staff for Policy Stephen Miller, who was also in my White House advisor slide. She served with DOGE while maintaining her job at P2 Public Affairs Consulting. This is a major Republican consulting firm that continued to pay her salary throughout her position. Consider also Steve Witkoff, who is the special envoy to the Middle East, also appointed as an SGE, special government employee. According to reports, he has engaged in peace talks between Ukraine and Russia. He's currently engaged or previous examples as well, is engaging in talks with Iranian negotiators. And he's also brokered real estate deals between US and Pakistan, despite holding on to a vast real estate portfolio, okay? Though political pressure seems to have resulted in some divestment, right? Throughout many of these actions, he seems to have still been holding on to much of his real estate. And I believe his son is actually the head of his real estate investment firm now. So there's my first type, okay? Special government employees who are hired to serve as high-level White House advisors. My next type are a category of actors known as detailees. Detailees are employees who are temporarily assigned to the White House from agencies throughout the executive branch. And this seems to be on sure statutory footing, okay? When Congress said, hey, it's a good idea for folks in agencies not only to go to other agencies, but they also seem to think it was explicitly, they mentioned the White House office as an institution that could benefit from often career employees at agencies. And this statute says, these detailees can continue to be paid by their home agencies for up to 180 days, after which the statute says the White House starts to have to be paying them and put them on their payroll. Despite this requirement, however, a 2013 GAO report suggests that this doesn't actually occur in practice. In other words, that agencies continue to keep these folks on their payroll even after the 180 days. Okay. So the implication of this is that the White House can temporarily expand its staff in this way without using its own appropriations from Congress for the White House and the executive office of the president. Presidents, too, have been using this authority to create the para-presidency. The Obama administration, it's my first picture here, detailed, that's Heidi Avery from the CIA to the White House to serve as Deputy National Security Advisor. The Biden administration, my second picture, brought in Dmitry Daskalakis, a detailee from the Centers for Disease Control, and he served as the deputy coordinator for the monkeypox response. In 2023, reports suggest that he was the highest paid White House staff member. And finally, the second Trump administration is relying on another detailee, the third picture there, from Immigration and Customs Enforcement, Jacqueline Klopp, who is serving as a presidential advisor in the White House, all as detailees. Okay, again, that by statute are authorized to be in these roles for 180 days, after which the White House has to start coughing up the funds for them. Finally, my last type are a number of actors hired through a statute called the Intergovernmental Personnel Act. And these folks are referred to as IPAs after the statute. I myself was an IPA from academia serving in the administration as a political appointee. And the White House, too, has been relying on this statute for its hires. This statute authorizes the temporary assignment of employees for up to 2 years into the federal government, although that can be expanded for another 2 years. But again, the statute ex ante puts a time limit. You go in knowing that you're not going to stay there, that there is a definite time after which you are legally supposed to leave, unless, again, you get this one extension. And the Biden administration, for example, used this statute to hire Lynn Parker, pictured here, as director of its entire AI initiative, the National Artificial Intelligence Initiative within the White House. Okay, and she was brought on board from the University of Tennessee, where she, maintained an affiliation as a full-time faculty, well, not full-time faculty, but as a faculty member there. Looking at the literature on para-entities characteristically emerge in response to constraints. The root institution is unavailable, insufficient in some way, captured, or formally restricted from doing what is perceived to be necessary. Returning to paramilitaries, for instance, as already discussed a bit, states often turn to them to handle unpopular unrest, protest, or insurgencies. And because paramilitaries are plausibly not part of the formal government, they could be used to shield the regime. Paramilitaries, in addition, are often cheaper and faster to deploy than the military or the police. It's much easier to get an SGE on board or an IPA or a detailee than it is to go through the ethics process needed to get a traditional White House advisor. And in this manner, para-entities fill these perceived gaps, not autonomously, but in structural coordination with the actors who face the constraint. This means that the conditions giving rise to these para-entities are themselves diagnostically significant. Identifying them, in other words, may be a key part of why the para designation is apt and when we can fruitfully use it in particular contexts. So the question, of course, arises, what have been the relevant constraints on the president? The most obvious, perhaps, is constitutional. The requirements, for example, under the Appointments Clause of Senate confirmation for principal officers. According to one recent study, the time for Senate confirmation has more than tripled since the Reagan administration. It averaged about 192 days during the Biden administration. For this and other reasons, the president has long turned from the cabinet made up of the heads of agencies to White House advisors. We've already known that that happened and already diagnosed that likely as a result of Senate confirmation delays. But the question still remains, what explains the shift from the White House advisors now to the more temporary and ephemeral para-presidency? One explanation is now the desire to avoid not constitutional but statutory constraints. As I've discussed, generally speaking, the IPAs and SGEs and detailees are not paid by the White House, but paid by their home institutions. So again, the president is no longer subject to the statutory salary caps nor appropriations limits. And the second explanation is the desire, as with paramilitaries, for agents that are plausibly part of and also not part of the government. Because the para-presidency still maintains these close private affiliations, it's easier for the president to assign it controversial tasks because, after all, its members are soon going to morph back into private citizens, just like Elon Musk did. According to one former member of Doge could act as the fall guy for unpopular decisions, like the widespread cancellation of federal contracts, the shuttering of USAID. And to paraphrase from F. Scott Fitzgerald's The Great Gatsby, the para-presidency could be made up of careless people that smashed up things and creatures and then retreat back into their money or their vast carelessness or whatever it was that kept them together and let other people clean up the messes that they had made. Taking a step back from these descriptive observations, why should we care? Is the para-presidency really a problem, or is it just a rational evolution in our executive branch? Perhaps most obviously, as I've already suggested, the phenomena, of course, raises serious concerns about corruption and self-dealing. Because the para-presidency amounts to quasi-private actors who potentially exercise what amounts to governmental authority, Elon Musk, for his part, could engage in a lot of the activities of Doge while still heading companies with over 50 government contracts across 7 agencies, reportedly totaling $11.8 billion over the life of the contracts. Second, the para-presidency has largely evaded judicial review so far. Efforts to argue that Elon Musk, for example, violated the Appointments Clause have been largely unsuccessful and will likely continue to fail. Under this clause, of course, individuals whose duties and positions make them officers must be appointed in specific ways, right? If they're inferior officers, they require appointment by the president, the heads of department, or the courts of law. If they're principal officers, presidential appointment and Senate confirmation. But challengers face litigation difficulties, even showing that individuals like Musk are constitutional officers, right, let alone inferior or principal. And that's because the inquiry centers on whether they occupied continuing positions established by law, to invoke the doctrinal tests in Lucia and Buckley. And in doing so, the challengers also have to show that there was the exercise of significant government authority. But first, members of the Para-Presidency, by design, fill temporary positions. And as argued by the defendants in State of New Mexico versus Musk, they are thus not in continuing positions. And despite convincing the district court that there was an Appointments Clause violation, the Fourth Circuit overturned that conclusion. And indeed, the Fourth Circuit, in a separate case, also raising this claim, John Doe's 1-26 versus Musk, the courts often buy the argument that members of the Para-Presidency are merely advisors rather than actually exercising the government authority. In this view, Elon Musk and Steve Witkoff merely advise, suggest, cajole, leaving the actual decision-making to those with delegated governmental authority. More broadly, these challenges struggle with fact-bound determinations like these because of the difficulty of getting courts to order extra record discovery against high-level White House actors. Indeed, Supreme Court precedent, for example, Cheney versus U.S. District Court for D.C., suggests that discovery against White House officials is particularly burdensome, and it should be a last resort, thereby making it difficult for challengers to gain evidence at litigation's early stages when it is crucial in order to win preliminary relief. Indeed, the D.C. Circuit in the State of New Mexico versus Trump case involving Doge stayed a district court decision to allow some discovery against Elon Musk. And as a result, challengers have been unable so far at least, to substantiate claims that Musk went well beyond cajoling and suggesting and advising. Instead, they claim that he invoked threats of legal risk for agency heads that refused to comply. They claim that he even invoked the threat of force deployed by U.S. Marshals if they weren't let into the buildings and given access to the technology and the computer systems. And these challengers were also unable to draw upon reports that agency heads, in fact, resisted some of Musk's suggestions, such as when the FBI's Kash Patel reportedly instructed his staff not to comply, at least initially, with Musk's demands for information from career staff with threats of job losses. Okay, so again, the sum total here is that the limits on discovery make it extremely difficult for challengers to even show what the scope of the authority being exercised was for Appointments Clause purposes and well beyond those kinds of claims. These litigation difficulties are exacerbated also by claims that these questions are now moot after the members of the Para-Presidency leave their government positions. And indeed, this is what the argument is currently being advanced by Elon Musk's lawyers after he departed Doge after 4 or 5 months to return to his business ventures. While the district court in the New Mexico case rejected the mootness claims based on the continuing availability of relief, this decision is likely to be appealed. And so we'll see what happens. But for all these reasons, legal challenges to the Para-Presidency, which often depend on these factual questions, face an uphill battle. A host of doctrines, from discovery limitations to mootness, currently facilitate the Para-President's ability to evade judicial review. So, what is to be done? Okay, and these are nascent ideas, so I really, again, am interested in your thoughts. But here, perhaps some of the lessons from the literature on the paramilitary and other paraphenomena may be useful. What does that literature suggest? Well, first, The first lesson is that transparency and accounting are critical. Basic facts about the para-presidency's size, scope, and the scale of duties exercised are simply unknown to Congress, academics, or the public at large. And believe it or not, history suggests that sometimes these basic facts can actually sometimes spur change. In 1972, for example, it was not until the House Post Office and Civil Service Committee collected simple data on the sheer growth of the White House staff that public outrage and congressional action ensued, resulting in the White House Personnel Authorization Act that I mentioned earlier. That report showed that the White House office, unbeknownst to the public and to Congress, had almost doubled in size from 1955 to 1973, from 262 to 510 in number. Who knows what the sheer scale of the para-presidency looks like today? To this end, Congress could, as it did in 1972, direct the White House to disclose all staff with these temporary designations beyond what's required today. There's some limited reporting of detailees, but certainly not of SGEs and IPAs. And with this greater transparency, as in 1972, perhaps will come the possibility of legislative change. A second lesson from the literature is that simply absorbing these para groups into the state often fails because these individuals are embedded in broader patronage systems or power networks. And so in an effort to weaken these corporatist ties, in other words, this literature says you have to think much more systematically than just whack-a-mole of these para groups. We thus might want to support legislation like that proposed by Senator Elizabeth Warren and Representative Melanie Stansbury in the form of the SGE Ethics Enforcement and Reform, or SEER Act. One of its provisions, for instance, would prohibit non-advisory committee SGEs who own, direct, or have a major investment in for-profit companies like Elon Musk from communicating with any agency that has government contracts with, regulates, or has a pending investigation into the SGE's ventures. A third and final lesson is that reforms, again, must think systematically and think about reducing the incentives for the root institution, here the president, to continue to use these distant proxies. And here I have two broad observations about the courts that give me some measured optimism that judges will increasingly step in to police the most egregious legal violations, if not on constitutional grounds for the reasons that I've offered, but perhaps on statutory ones. Okay, these statutory grounds include claims that the authority exercised was ultra vires. We could get more litigation about the use of the SGE statutes and IPA statutes for high-level White House appointments like these. There can be litigation about the temporary organization statute that was used in the Doge EO, or in violation of trans-substantive statutes that are all near and dear to our administrative law hearts, including the Administrative Procedure Act, of course, the Freedom of Information Act, or the Privacy Act. What gives me some measured optimism? Well, first, the Supreme Court's increasing embrace of the unitary executive rests on the premise that executive officials operate within established hierarchies. The para-presidency, however, fragments authority and reduces clear lines of control beyond the constitutionally settled White House advisors, effectively creating these temporary shadow decision makers that blur accountability, and to use a phrase from Supreme Court decisions. In fact, so comical was the White House efforts to tout Musk as the head of Doge, while for weeks government lawyers first claimed not to know who ran it, and then eventually they pointed to a mysterious individual named Amy Gleason, who was actually heading Doge. It led her to start the WITAOD Chronicles, Who is the Administrator of Doge? And there, she documented the government tying itself in knots over the question, leading her to ultimately call it Schrodinger's bureaucracy, after a famous thought experiment in which a cat in a sealed box is simultaneously alive and dead. This is beyond my pay grade. This is a physics thought experiment, but I hopefully it conveys the idea. I am hopeful that obvious efforts like this to blur the lines of accountability will lead judges to increasingly scrutinize high-level temporary actors with more skepticism. And this leads me to my final observation, this one about pretext and the presidency. Generally speaking, courts remain hesitant to second-guess presidential motives. When these decisions, however, translate to agency action, courts have been more willing to look beyond litigating positions and the record to look more closely at the realities that are apparent right in front of them. As the court memorably said in Department of Commerce versus New York in the context of the Administrative Procedure Act, our review is deferential, but we are not required to exhibit a naivete from which ordinary citizens are free. In other words, even judges are not always willing to go along with obvious charades and obfuscation, particularly when bad faith seems to be involved. Thus, when the para-presidency claims to be merely advising, but is in fact exercising significant government authority, courts should be more willing to look beyond the staid record and allow for limited discovery during arbitrariness review, including sometimes asking high-level officials to testify. Jill and I spoke to a potential increasing willingness of district court judges to do so. By the same token, courts should not be quick to dismiss cases as moot, lest temporary actors evade judicial review completely. And so we return, in conclusion, to one of the analogies with which we began, the paramilitary. Again, these are actors that operate in the shadows of formal authority, close enough to wield power, distant enough to evade responsibility, and they're useful precisely because they blur lines between public and private, between command and suggestion, between accountability and deniability. The para-presidency, I've argued, functions in much the same way. But it is not an accident or an aberration, but rather a structural response to constraints that operate in the interstices of law. And like paramilitaries, its very utility lies in its ambiguity. But if that diagnosis is right, it hopefully points us towards some possible paths forward, because history again suggests that systems built on ambiguity back then, like White House advisors more generally, are not indefinitely unstable. They invite scrutiny, they generate friction, and eventually, it took decades and decades for White House advisors, but eventually they provoke demands for scrutiny, for clarity. The task then is not necessarily to eliminate every paraform. Indeed, maybe some serve valuable purposes, but rather to bring them into the light, to make visible what has been obscured, to align power with responsibility, and to ensure that those who act in the name of the state are answerable to it. Our constitutional tradition, at its best, has often chosen this path, and with the help of lawyers like those trained at the Law and Government Institute, there's good reason to believe it can do so again. All right, welcome questions, thoughts, suggestions, how to fix this, if you think it's a problem.
Realize that this had been going on prior to the current administration, but clearly, based on your presentation, it has, and so it may be the scope or the unpopularity of what's happened that sort of brought it to the forefront. Can you envision a situation where there might be broad agreement that a certain type of outsider is needed to solve a problem, and that the structural issues can be addressed to fix the conflicts and the transparency and accountability issues, or is it just so inherent in bringing someone in from the outside that you can't fix it? Because it seems like the reason why people are brought in is specifically to try to get around the bureaucracy. So I'm wondering if there's just too much of a tension there.
Yeah. So I've been asked to repeat the questions for folks listening on Zoom, so I'll do my best to restate it. But
Long one,
please,
yeah.
please, jump in if I haven't. So if I were to restate the question, one version of it is the question of whether this state of affairs is somehow inherent to a felt need to bring in outside actors into government for specific purposes, or by contrast, whether it is like a structural failing that could actually be reformed in a way that would reduce that need or incentives. Is that? Okay. So a few thoughts, and they start with reflections on the legislative history for the statutes that I discussed that have been relied upon by presidents to do all of these things. And, interestingly, many of them were in the 60s and 70s, and it was in response to this idea that what was lacking was expertise to deal with novel technologies in government, so whether it was like nuclear technology, and there was a sense that, for the IPAs, for example, like we can't get people to leave their cushy jobs at universities, but how can we get them to provide their expertise and so on? And so this is just to say that I do think that Congress, in response to that need, has designed these statutes in order to meet the need. But the problem is that how they are being used now, arguably, is not for those same expertise-related reasons. And it's for more of these more nefarious reasons that I'm suggesting, to deflect blame and evade review and so on. And so I suppose this is just to say that, I do think that there will always be that felt need for actors to be recruited into government that would otherwise not be able to serve, whether for financial reasons or because they don't have any incentive to, again, give up their cushy jobs or lucrative positions, right, to serve into government, and then because of that felt need, the question is what's missing with Congress's efforts to do to do this so far, and again, I think that the combination of disclosure with provisions like the White House Personnel Act for high-level officials will help with that, and maybe it's ultimately like a political question in terms of like what is the right mix of expertise and the potential for conflicts. But I just want to recognize that it is, I think it is a system that has evolved over time to meet a need that will continue. And maybe I'll just end by saying I welcome the flexibility into government. Like I do think there needs to be real thinking about how to get folks into government that wouldn't otherwise serve. And, maybe the right mix is, like the legislation, proposed by Ward and others to, try to tamp down on the, the reasons that weren't the original reasons for bringing in these actors, conflicts of interest and so on, tamp that worry down in favor of actually drawing in the actors for the reasons that we want them to be serving in government. Yeah.
I am in agreement that folks that are pretty much put into these positions, so let's call it handily, shouldn't be really taking over or making decisions or even scaring people into doing their bidding. I'm in agreement that that shouldn't be the case. And I'll be interested in seeing in about a couple of years, let's say 5 to 10 years, to see what the actual impact was or is once we have that data. My first question, would you argue that perhaps the creation, and I like the Para-Presidency statement, of groups that we see or appointments that we see is a byproduct of the changing times and how quickly some things need to happen or move in order for change to actually occur, given the snail speed, as I like to say, of our wonderful systems?
Yeah. Okay, so for the folks on Zoom, first, the gentleman agrees that this is a problem and thought that my comments were very prescient and okay. So basically agreement that this is a problem and wants to see how this will develop. Yeah, exactly. Take my prerogative here. But the question was, and it's a terrific one, which is, and it's kind of, I think, related to yours, right? Whether this evolution is a necessary evolution given the, you said byproduct of changing times. And we could, you could have in mind a number of different things by what we mean by the changing times. Like one could be kind of sort of the novelty of the sort of systemic risks that are facing the government today that may be greater in scope than in the past, okay? Maybe, maybe not. I mean, I think a lot of folks would say, no, they're no greater than, but I mean, I look at some things, like climate change, AI, financial, emergencies, systemic risk, right? And the scope of those risks is giving rise to the development first of White House advisors, and then increasing specialization of White House advisors, earning them the name of czars for these different tasks that they're going to be focused on, to the para-presidency today. And I've already discussed all the reasons why that shift potentially has occurred. So this is to say, if we buy the premise that the scope of risks facing the government is larger, maybe something like the para-presidency, done the right way, is a positive evolution. Question. We're done the right way, yeah. Big, lot of weight placed on that phrase. And then the second thought is, what is the byproduct of our changing times is just polarization. And the question of, how much of this is actually a felt response to trying to speak to the base of, different parties and the polarized nature. So it's not a coincidence, I think, that the para-presidency has been really focused, think immigration, think, shuttering USAID, cutting the civil service. They are a way for the president to signal very publicly that he is meeting these priorities that the base wants him to serve. And so if we think polarization is going to continue, and I see no signs that it is abating, then that too, I think, might help explain the pressures for these kinds of actors to develop. And, in some ways it's going to be a question of, do we rely on courts and whack-a-mole? Can we actually get the political will? I'm not holding my breath for a systemic change, but once again, I'm a little bit comforted by history that sometimes the right constellation of factors, maybe even filibuster reform here is necessary, but the right constellation of factors can maybe lead to a more systematic response. Yeah, Jill.
Coming up with some new legislation like they've done in the past to essentially regulate how the executive branch does its work. But every time I hear someone now say, oh, Congress could do something to regulate the way that the executive branch does its work, now sadly I immediately think of unitary executive theory, which we don't really know the boundaries of. Like right now the Supreme Court's just thinking a bit in terms of removal power. But it seems to me, if you take unitary executive theory to its max, who knows where the line is? Like, if we're reimagining how Congress is allowed to control the executive branch, like, who knows where the Supreme Court is going to end up? And so I think I heard you say that, you know, maybe thoughts of accountability will push the Supreme Court to say, well, you know, we're not just going to give the president free rein to do whatever he wants. But I'm just wondering if you thought more about, you know, what happens if the Supreme Court says that Congress, you know, can't say he's only served for 180 days, right? Like, what if that's interfering with the president's Article 2 executive power?
Yeah, that's a great question.
Then where are we?
Right. Okay, so to restate it, the question was sort of what constraints might a court, fixated as it is on the unitary executive, place on Congress seeking to constrain the para-presidency in the right way? You know, the examples that were given of, you know, even disallowing the president to hire detailees into the White House office might run afoul of the amorphous bounds of the unitary executive. And I think that that's a real question these days. I guess I think about strands of the unitary executive doctrine that are so formally fixated on the removal power that I tend to think that once the court overturns, severely limits Humphrey's executor, and they are, you know, finally feel that Congress cannot limit the president's removal authority, I guess, you know, I think that there's enough of a tension to then start looking more broadly and more functionally into all these other different methods of control that in case after case, the court has said that's not enough. That's not really, you know, control, right? All these cases where they say, oh, you know, simply like review is not enough. And oversight, and you know, we need to. I'm thinking of Free Enterprise Fund and just all the different ways in which, you know, the SEC actually controlled the entity there. That's not sufficient, and so I don't know. I mean, I kind of feel like the court is going to say, look, the unitary executive is achieved when we have removal at will. I don't for a minute think that Congress can you know, limit the removal of any of these actors, and I suppose I also want to just situate this kind of whole move and system of governance and kind of also put it in conversation with other ways in which Congress has regulated the president's ability to use temporary actors, because I have not even touched the huge role of contractors in government, which similarly serve these temporary roles. AI is already being used in government, right? That is another form of really interesting, that's a whole other talk we could have, a session we could have about the role of AI. And the point just is that Congress has certainly regulated contractors much more. And, you know, courts, I mean, it's in different contexts, right? But courts seem to recognize that, you know, that there is sufficient reasons and constitutional basis for Congress under the necessary proper clause and so on to pass this kind of legislation. So the short answer is, I think there is reason for concern, but I kind of think the court will be happy for a while once it's gotten rid of tenure protections. So on that note, thank you, everybody. I don't know, I think we're out of time, so appreciate everyone's questions.